Hi everyone, thank you for joining the webinar on how the US sports market has impacted on the global, or sports law market has it impacted on the global sports market. We started slightly late to give everyone an opportunity to register and join. We're expecting around 70 attendees. The webinar has come about because of our long-standing relationship with the Sports Lawyers Association, and for those of you that don't know, we'll do an introduction to the Sports Lawyers Association and what their work they've done over the last 40 odd years or so in the global market, but also in the US market, and also particularly because the Sports Lawyers Association annual conference is coming up next week. It's very relevant to highlight some of the issues that are going to be discussed there, but also more broadly having, as I work with LawInSport, we see the impact that the US market has globally. We get a lot of questions from our international members and our readers about this, and so who better to answer these questions than our expert panel, who are all board members of the SLA. Thank you all for joining. I'll introduce you guys shortly. Before we start, if you're not familiar with the GoToWebinar app, you do have the ability to ask questions. Some have been submitting in advance. You can raise your hand, which we'll be keeping an eye out for. If you do have any things you'd like to interject with or contribute, ideally we would leave any statements to the end. We ideally want questions rather than statements from the panelists. And I shall just flick ahead so you guys can see what's next. So first up, we've talked about the conference, we've gone through the ground rules, and then hopefully everyone can see my slides. We have our speakers. So first up, we have the chair of this year's Sports Law Association annual conference, Richard Thigpen, who has returned to private practice as counsel at Kirk, Palmer and Thigpen after serving as the general counsel for the Carolina Panthers for 21 years. He's had an illustrious career and has got a fantastic perspective on all things related to sports law, but particularly from his general counsel experience, so we're delighted to have him on. Next up, we have Alison Rich. Alison Rich, as I said, is also a board member of the SLA. She has holds significant leadership roles in and has decision-making experience, having served as NCAA national office at both large state and small state FBS, FCS, and Division I institutions.
I can explain.
That's a mouthful, and yet you may need to explain that for my benefit as well as everyone else. And I should say there is a handout that has everyone's bios in that you can download, so that's the reason why I'm quickly going through it, so you can actually have a look at those at leisure in your own time. Alison is now the Senior Associate of Director Athletics and Senior Women Administrator at Princeton University, and she regularly lectures and speaks on sports law issues in a variety of different roles. And I believe he's been on the SLA board for something like 15 years now or so. And was also the conference chair of last year's conference. So has a great overview of the big issues from last year and what's on this the agenda this year. Next up, we have Jeff Benz. Many of you will know him from his work as an arbitrator for the Court of Arbitration for Sport. He's an arbitrator and mediator with JAMS. He's also recently qualified, congratulations Jeff, as a barrister in England and Wales, and is at 4 New Square Chambers. Jeff has been involved in some high profile cases, and so I'm just seeing some ignore the bottom half. We've got Richard's profile, sorry Jeff, but we've got Richard's profile interjected into yours on there. But anyway, Jeff has been involved in some of the most highest profile cases in relation to arbitration in sport, whether it's anti-doping or other issues, disciplinary selection and safe ball issues. So Jeff, thank you for joining. He's also the co-chair of the International Outreach Committee for the Sports Lawyers Association. Jeff, is that correct? Did I get that title correct?
There are 2 committees. One is the International Committee and one is the Outreach Committee. So I'm a co-chair of the International Committee.
You did brief me before. So you're the co-chair of the International Committee. So Jeff basically works internationally to create partnerships for the SLA and again, do events like this and really explain what's going on in US sports globally. So thank you for joining, Jeff. Jeff is also a LawInSport editorial board member, so I should thank him for that. And Norm Wain is the General Counsel and Chief of Business Affairs for USA Track and Field. Norm is responsible for overseeing the legal department at the USA Track and Field, looking at negotiations, managing corporate governance, handing out open meetings, overseeing litigation, intellectual property, and managing agents, and a whole host of other issues. Norm is the co-chair of the Outreach Committee. As thank you, Jeff, for pointing that out to me, the distinction. And he's also a advisory board member for LawInSport. So first up, I thought, Alison, given your role as a long-standing board member of the SLA and being the chair of last year's conference, could you give a bit of a background to what the SLA is for those that aren't familiar, because I think it will put this whole discussion into context, and then maybe highlight for you some of the key, I don't know, 3 or 4 key talking points from last year's conference, and then we'll come on to Richard to talk about what the focus is for this year.
Absolutely. So thank you for having me, Sean. I'm happy to be here with my fellow panelists. The Sports Lawyers Association, we like to think of ourselves as the premier organization for anything related to sports law. And we've grown over the years significantly. When I first started, gosh, I don't want to say how long ago, when I was about, a little kid, we had a much smaller group of practitioners in a smaller area of practice, and our scope has expanded significantly over the years. It covers professional sports, covers amateur sports, covers anything that's related in any way to sports and the law. And we like to provide the education through our annual conference, which is a wonderful conference. It's a 3-day event. We go to great cities and get together and share a lot of information and ideas with each other and talk about a lot of the hot button issues of the day, as well as some things that might be important for people in their daily lives and practice, as well as in their interests. We've seen the group grow over the years. We now regularly have close to or over 900 attendees every year at the conference, and significantly more members than that, providing more information throughout the year, like webinars, things like this, resources, materials that come out, publications, outreach events, which some of my colleagues will talk about as well. So really trying to provide whatever service our members are interested in, need for their learning, as well as for their networking and just contact experience. So the conference has changed a lot over the years as well. As I said, it's grown significantly. I think there were about 250 attendees my first year, and now we're regularly around 900 people, 900 people, which is a fantastic group to have together. But as you can imagine, the area of interest and expertise and practice is really broad. We've expanded the law students that attend, so we have more programming that helps them. We've expanded the programming. Our breaking in session, we rebooted a little bit for a lot of attorneys who are looking to break into the sports law industry in some way or learn more about it. We have that at the beginning of the conference to provide a networking opportunity and a bit of a cohort feeling, so that those coming for the first time or learning more about it have a group that they can talk to throughout the conference, as well as learn a little bit about how to navigate the conference when they first get there. We cover, as I mentioned before, a lot of the hot button issues, which sometimes tends to squeeze out some of the regular everyday type issues. So we try to include as many of those as we can in our breakout sessions, which have grown as well. We used to have a handful of those, and now we regularly have about 13 breakout sessions with different areas of interest, so that we can meet as many of the needs and interests as possible of our members.
And what would you say from last year's conference? What would you say were the sort of really hot issues? I should imagine sports betting was probably would be, I'm sure, top of your list. But what were some of the others as well?
Yes, that was number one since the decision came out about a week before the conference, so it was hot on everybody's mind. Esports is one that we've been talking about quite a bit lately. We finally stopped talking about it as the upcoming thing, as it's here and it's huge. So we talk about that quite a bit. Some issues with venues. We have a CAS session, so a lot more about the arbitration process and the connections there. A lot of sessions that are of interest to some of our international members as well, and not just those who are in maybe some of the major sports in the United States, really trying to keep track of what's happening. We also always have a college athletics session, which last year we were again talking a little bit about the gambling and some of the antitrust issues and lawsuits that we've been dealing with there. So trying to give as much information as we can with speakers who are really engaged in this on a daily basis and can provide that information to our attendees.
Brilliant. So we'll come on. I think we're going to come on to some of the college issues, given obviously your role, and so you've teed that up nicely, because I think, again, for the international audience, we talked about this before offline, and maybe people aren't necessarily familiar with the college model in the US and how big it is. I'm always astonished when you see the numbers. And myself, yeah, it's really huge. Richard, as the chair of, so that tees up nicely actually, I think, to you, as the chair of this year's conference, what are the ones that I guess that for you stand out? Is it still, obviously sports betting, I should imagine, is going to be pretty dominant in the discussions, but what else? Or that?
Yeah, Allison touched on a lot of it and did a great job. Like she said, we focus on a number of big issues that for our plenary sessions, and then we try to hit other buttons on the breakout sessions on Friday afternoon to make sure everybody finds something that they're interested in. You get to attend 2 of the breakout sessions, so there might be 12 or 15 to choose from, and hopefully everybody can find a couple that they like. Our plenary sessions this year are about esports as the next and not so next big thing, deciphering the hype on the impacts of technology and social media on sports, athletics issues through the lens of college and university counsel. We always have an ethics session, and where most classes that you go to will give you quick nap time. Ours have been very entertaining. It's role playing. It's really interesting and also informative. Then there's a session on athlete abuse, the human and legal rights issues.
And so, sorry, one thing to touch on, on that ethics side of things, I think that's something that is slightly different in the US market generally. You have compulsory ethics requirements, which sees obviously a lot of attendees. Maybe you can just, again, for those who aren't familiar with the US legal market, it might just be worth briefly just explaining what that is and what the requirement is, because I think that's something that is not necessarily that familiar for people outside of the US.
So the requirement by state, because you're licensed by state bars, but in North Carolina you have to get an hour or 2 every year and a 3-hour block every 3 years. The 2-hour block that they offer, and the idea is just to keep it in the forefront of your mind as an attorney that you have ethical obligations to your client and to the public and to the profession, and so our seminar tries to put these issues out there in an entertaining and informative way, so that somebody's not just reading to you the canons of ethics. We're talking about specific role playing, specific issues that you face as in-house counsel or as an agent or whatever your role might be as an attorney, and then they'll specifically reference the canons that are impacted, but it is to keep it in the forefront of your mind as you practice.
And we can probably talk about that on the college stuff, because there's some really interesting ethical issues that have been taking place in the US around some of
Absolutely. It's my life.
So before we do that, and then so the format will be, we'll go to Richard first, back to Alison, then to Jeff and Norm in terms of, but guys, feel free to interject or add anything that you see fit. So Richard, obviously you had this extensive career as a general counsel.
Before we leave the conference, can I just talk a little bit about the international aspects that we have at the conference?
No, of course you can. Yeah.
It's my chance to plug it. So we typically at each conference have a sizable block of content that's directed to an international audience, or that's directed from an international audience to our audience, to teach and talk about things that might exist as common problems, but with different solutions in our different legal systems. Last year, we had the COO of UEFA, Alistair Bell, who 2 months or 3 months later became the COO of FIFA. So for those of you that follow football, there's no bigger name than that, really speaking, on the circuit, because Infantino doesn't belittle himself by coming to sports like that. But Alistair will. And so this year we have content in a roundtable or a breakout session about comparative aspects of how athletes get treated under various legal regimes. We will have a high-level delegation from China, from the top government office that regulates sport in China, the All China Sports Federation / General Administration for Sport. They'll have delegates there attending again. This is not going to be the first time. We also conduct an international breakfast on Saturday morning, so that people with an affinity toward international things, or that come from abroad that want to network and meet people, can do that specifically on Saturday morning. And there's copious amounts of networking that goes on throughout the rest of the conference. So
thanks. You now don't need a plug, thanks. Is one thing that I do want to come back to you on, though, is how you've seen the interest from the US audience, because whilst this is about how the US market has influenced the international sports market, which I think it undoubtedly has, and has that sort of, just looking at maybe Richard, you can talk about some of the concussion, how that's developed over the years when you were, from your role as general counsel, but you've seen this, much greater attendance than I've been anyway on the international sessions from a lot of the US lawyers as well. Thanks for that, Jeff. So, Richard, can you talk about over your time at the Carolina Panthers? Can you describe what you saw change and what was the sort of big issue for you that you think have been, pervasive within the wider global market? And I can, again, drawing on the concussion being the number one that I can think of, but I'm sure there are many more.
Okay, and quickly before I launch into that, Jeff has been single-minded and single-handedly done wonders to build our international focus within the SLA. It's over the last 10 years, it's gone from 0 to 120, and it's all because of his efforts. So those of you that come from outside the States, say thanks to Jeff next time you see him. But yeah, over the last 10 years or so in football, the two really hot button issues were the head injuries, the CTE, and player discipline. And both of these are kind of started with the NFL in a way, but they bled over into all the other sports, national and international. The concussion syndrome is something that it was really hard to get your hands around. I mean, was there an assumption of risk or not? Was there a lot of obfuscation, a lot of hiding things by the league and by others? There were lots of worms in the can, so to speak, that never came out because they got to a settlement. And I, for one, am probably glad it never came out, but it got resolved, and with a mass settlement with the players, and these were players that went back. Anybody that was alive that had ever played football up to a certain point in time was entitled to benefits under the settlement. It's a $1 billion+ settlement, which some is a drop in the bucket for what it's really going to cost the players and their families. At least it is a start, and who knows where it'll end up. The settlement also doesn't cover workers' comp claims, and I got a feeling you were going to see some workers' comp claims. Those are state law claims. You can't settle those through a settlement like they had with the players. So I think you'll still see claims on brain injuries through workers' comp, and the workers' comp typically is a short-term benefit, but with this it might be a lifetime benefit. So that's going to be really interesting to see how that plays out.
What's one of the challenges with the workers' comp then, in terms of bringing that claim? What's the hurdle, I guess?
The hurdle is a statute of limitations. So it
right.
varies from state to state. It's North Carolina, you have a 2-year statute of limitations from the time you knew or should have known about your injury to file your claim. California, you have a 1-year statute, but it doesn't start until somebody tells you that you've got a disability. And so that opened up a Pandora's box in the NFL for a while for regular injuries. It's going to be a tough hurdle for the defendants to overcome on comp claims in California.
And that's quite interesting on that side. So the related on the global aspect, the related issues around insurance and let me
talk on that, Sean.
Yeah, go for it.
Yeah, so I mean, as Richard started to mention, the science behind the concussion issue is still to this day not exact, and so as a result of that, it makes the defense of any insurance claims really complicated, because it's really difficult to measure the damages, and it's really difficult to show causation or disprove causation depending on the type of situation. So even a governing body like track and field, where in theory there isn't the head-to-head trauma that would take place in the National Football League, or even in football as it's spoken throughout the rest of the world, where players can collide heads or they're heading a ball on a frequent basis, doing things like that, and what are the impacts of that? And so the kind of, from a U.S. perspective now, on the grassroots youth level, more and more states are starting to put requirements for coaches to be educated on concussion protocols, to institute certain concussion protocols within field of play type situations.
That's across sports. So that's across sports.
Correct, exactly. Not just
College too.
College too, exactly. And so as we deal with it, again, like we have had some concussion cases, and when it doesn't appear as though the injury would be that significant, when you're having a tough time disproving kind of the allegations because the science isn't really there to substantiate a position, it makes it a very complicated analysis. And
that's interesting to see. What complications, if any, does that represent if your your athletes are competing internationally? Obviously, the NFL now have games in London. We have a few games in London, but obviously in athletics, you compete in track and field. You compete in a whole bunch of different sports. And I'm sure in the US, a lot of the college teams travel and tour. So what sort of issues does that represent when you're putting that into an international context? Must be a bit of a headache. I'll leave now. I'll leave you. That wasn't intended. The pun wasn't intended. But yeah, that must cause some difficulties.
Well, the Panthers never played in London. They're going to play there this year. So we didn't face the claims. I would assume that as far as things like workers' comp claims, that it'll be the home state of the team that's playing over there for any injury that happens over there. I really don't know the impact on other claims of playing overseas. I do know that a number of years ago in the conference, SLA conference in Atlanta, when they were talking about expansion overseas for some of the U.S. sports, basketball, football, where you've got unionized employees, the labor rules are so different in Europe as compared to the United States. And in a lot of what we collectively bargain for, you really can't collectively bargain for over there. And that's going to be an interesting issue to play out when and if leagues start consolidating or expanding, whichever the case may be, to get overseas.
That's really interesting.
International federations are going to need to step up on that, because I remember there was a lot of outcry, especially on a concussion issue during the World Cup as it was playing out in 2018. There was a couple of incidents where players looked like they might have been woozy, and they were playing in a National Football League game. They would have had to go through the concussion protocol before they make their way back into the field of play. But in that particular game, they were out on the sidelines. They kind of, got themselves together and then re-entered the field of play. And so I think the international federations are going to need to take the lead on whether, how they want that governed in those international competitions, which I think is what you were asking.
That's right. And it's spread legislatively. It's spread across the United States, too, to reach colleges, to reach youth sports. I was involved in lobbying efforts in both North Carolina and South Carolina to get state laws passed that required an athletic trainer or somebody who's versed in concussion protocol to attend every high school sport, and trying to push it down to the youth sports. If it is that entrenched in American sports from youth on up, then it's going to have to be this kind of protocol is going to have to apply internationally.
Yeah, you start to question why it's not, and I think that's it's something I'll be, when I'm over in Phoenix, I'll make sure that I speak to a whole bunch of people about this to find out what's going on. No, but quite seriously, it's quite interesting, because again, sometimes the international audience doesn't quite know what's going on in the US. They see the NFL stuff, don't see how it's necessarily trickling down. Although we have seen some stuff with some coverage of the heading issue within football. Within soccer, as you would say. And then the other thing that I thought was that you mentioned, Richard, sorry, that you wanted to touch on was athlete discipline, which I think is something that is how the NFL teams in particular, how the major league sports deal with athlete discipline through that collective bargaining process is very interesting.
Well, the kind of two biggest issues are, one, what are you going to apply it to? Because right now, players get disciplined for on-field conduct and off-the-field conduct. Yeah, domestic violence, criminal activity, whatever it is they're doing. And is it, who's the best to discipline? Is it the league? Is it the club? Is it some other governing body? And how are they going to be consistent with the application of their rules? Because that's one of the big complaints about the NFL is a lack of consistency, not only among the players, discipline for players, but discipline owners and front office, because those people make mistakes too. And so how do you get a handle on this so you can get some consistency? And it needs to be, with so many international sports, it needs to be consistency across borders, not just within a sport.
Well, Norm and I had a conversation actually about this very issue, because I thought it was very interesting in the NFL, again, that their investigations team is so big to deal with these, particularly with the athlete instances off the field of play. And we were just describing from a European perspective, and particularly an English perspective, about where the limitation is for that, how far it should be policed. And the response that we got from I won't mention the name because it was an off the record chat, but the response that we got during that conversation was, look, yeah, we agree that maybe we're not the people to do this, but the public opinion is such, and the political pressures on us are such, that we have to take our own action and do our own thorough investigation, even if criminal, say for example, it's relating to a criminal offence that gets later dropped, the NFL will still need to investigate quite thoroughly, which I just thought was really interesting, because we're starting to see that sort of trend start to come across into other sports as they try to grow in value in their brand, I think. Norm, right, you were there.
Yeah, I was going to say, go ahead, Richard.
I was just going to say, doing a thorough and impartial investigation gets more and more difficult with social media too, because everybody's got an opinion that's out there instantly. People who are accused are guilty before they even know they've been accused, and it creates some real problems. Go ahead, Norm.
There's also a shifting of the landscape, because it used to be where the sports entities would kind of take a back seat and say, hey, this is a criminal matter, let's let this situation play itself out, and then once it's been adjudicated, then we can, if they've been adjudicated guilty, then that we can issue some discipline at that point. And the National Football League has stepped out and said, listen, we want to conduct our own investigation. We want to make sure that we are taking proactive measures to protect the integrity of our sports product, right? And so they will do things regardless of whether criminal actions are brought or not brought, if they feel that it violates the NFL rules that they have established for player conduct. And so as a result of that, then they will go ahead and issue discipline, even though the matter may not have been adjudicated against the player. And they can still be subject to discipline in the NFL, even if their actions were not even criminal per se, but it was considered to violate the NFL conduct policy.
Yeah, we see a lot of, and they've got the Falau case, haven't we, at the moment? Maybe Jeff, you.
Yeah, I was going to say, basically, I think in UK now you're seeing a greater march toward this. Maybe not as much in the Premier League and the FA as models in front on this, but certainly British horse racing has a very deep, wonderful investigatory arm in terms of how it deals with each allegation of on the field or off the field conduct relating to jockeys and horses and the care of horses and things like that. We don't have a similar thing in the United States. We have 50 states that regulate horse racing in a very disjointed way. And so, comparatively speaking, British horse racing is way ahead of the curve on that. Rugby is way ahead of the curve on that. I mean, rugby deals with on-the-field violations after the game or after the match is finished on a regular basis. And then you see the Falau case that you mentioned in Australia, where, yes, having to deal with people's opinions on social media can be difficult. But as an investigatory matter, when people are using social media to create evidence that involve their case or involve the merits of claims against them, it becomes a different animal. I can say as an arbitrator, both on the commercial side and in sports cases, that unfortunate things said by people on social media have now become increasingly evidence in the case, and you can't get rid of it. It doesn't disappear very easily. It's eminently findable, and it goes often right to the merits. I had a case that in part turned on that was worth several $1 million in the entertainment space because of something somebody put on social media. So it's alive.
So that's interesting, because you got obviously one of the things that we were going to talk about was athlete welfare, athletes as brands. You've got the collective bargaining situation where the in theory anyway, at least the owners of the major leagues and are aligned with the objectives of the athletes. Alison, obviously there's a lot of tension around that given the value of US college sports. So maybe you can talk about some of those related issues that have come up in the college sport and how you've seen that evolved and where you see it going in the future.
Yeah, so it's interesting because our model is obviously different. You know, we have the NCAA, which is a membership association. So unlike a professional sports league or any kind of national governing body, there isn't that same kind of direct authoritative action. There are NCAA investigations, there are penalties, but anything that's investigated on that level, it's investigated by the staff, but it's all decided upon by either the Committee on Infractions or Infractions Appeals Committee afterwards, which are made up of members of the NCAA, different schools and conferences. So it's all pretty much self-governed. So Jeff and I were on a panel about this with the last year and talking about the differences when you have institutional control, which is one of the #1 principles of the NCAA. That's each school can choose how they operate, what their policies are. You know, there's a certain set of rules, NCAA rules, which is for competitive equity and fairness and things like that. And there's more and more coming that regulates the health and safety, which is relatively new in that direction. But there are also decisions being made on the local level, which are going to be different from one school to the school next door to the school a state away, across the country, et cetera. So it's been interesting to see the different directions things go. You look at something even like an equity situation or some of the sexual violence that's cases that are coming up now, and there are decisions that are made from a legal perspective that are going to be very different from the decisions that are made from an NCAA rule perspective or even from a university policy perspective. So we're seeing some of that now with some of these lawsuits and what's coming up and threatening or challenging, I should say, the principle of amateurism and how the NCAA operates. But for now, things seem to be holding steady in that way.
It's interesting. One of the things that I thought, I'm not sure if you would agree with this though, but one of the things that was always a surprise to me looking at the international space, and we'll come on to some of the other integrity issues around safe sport and all the things that have been going on quite high profile on that, but was the Title IX. So maybe maybe you can talk about that again for the international audience who may not be familiar with it, about how that operates, because women's sport, particularly in the UK, I think globally at the moment, is having a real injection of enthusiasm and investment, which you guys have seemed to have on statute for some time now.
Absolutely. The statute is over 40 years old now, and it's basically, it requires gender equity in higher education. And that's where it started. It's a very simple, short statute, and it's been interpreted over the years and applied in different areas. And athletics was pulled into it, thankfully, a number of years ago, because all schools are recipients of federal funds in some way or another. So that law then governs what our actions are. And so what it says is that you cannot discriminate on the basis of gender for participation purposes. So in the NCAA, with our programs, there's different ways of achieving compliance, and I won't get into all of those, but you're looking for equitable participation opportunities for men and for women. And the challenges tend to come up when the underrepresented gender is not receiving equitable treatment. And that's not a pencil for a pencil, that's not exactly the same dollar amounts. It's the treatment has to be fair and equitable. So are teams getting the same types of competition facilities? Are the uniforms of the same quality? So understanding that, a men's basketball sneaker, which is this big, is going to cost probably more than a women's basketball sneaker, but are they of the same quality, things like that. And that's on a very micro level. But on the bigger picture level is how are the different teams and the different genders being treated, and are they provided with those same opportunities? So you can look at it from a numbers perspective, you could look at it from a treatment perspective, but a number of different ways.
That's really interesting. And how effective has that been? I know that I interviewed Jeffrey Kessler last week, and he's involved in the women's soccer team, the US women's soccer team. Is that a Title IX led or not? Is that something different? Is that different litigation on
I I don't think it's Title IX because it's not
Right.
federal
College.
funds, or
Yeah,
although,
yeah.
Well, and that's anything related to federal, but this
Right,
is, yeah,
right.
it's academics. But yeah, it's true. I mean, I think, sorry, you look at the different ways that things play out, and you look at what the opportunities are for some of the teams, and there's more and more interest for women participating. And I think there's always the concern that if you add the opportunities for women, it takes away from the men. And I think the evidence has shown that over the years, both opportunities have grown significantly, and allowing for that participation, that opportunity for education through sports in the college level.
And sorry, yeah, go for it, Norm.
I was going to say it's had an impact on college sports in general, because I mean there's very few sports at the collegiate level that are true revenue producing sports.
Correct.
And so as universities have tried to implement a lot of Title IX, it has had some financial ramifications to their athletics departments in general, in terms of making sure that they're able to execute in the manner that they're supposed to. And it's caused some challenge for some Olympic sports to maybe not have programs at the university level because the funding just hasn't been able to be there.
Right. And Sean, go ahead.
Yeah, go on, Karen.
I was going to say, you had asked how that was going, and I think that's some of the concern, that this is not something where every school is in complete compliance at this point, but I think everyone's trying to make that effort. But the cutting of sports it's unfortunate, because that all comes down to budgeting and what the institution can support. So it's finding a way to have those equitable opportunities available without having to sacrifice the opportunities of one that already exists. And as you say, Norm, that's a challenge, and that's something that we've seen, where there are a certain number of sports that have been cut over the years on the men's side, and not from Title IX directly, but I think sometimes Title IX is blamed for that, which is unfortunate, because it does set things back when all you're really looking for is a way that everybody has that chance to participate.
It's good. Yeah, it's going to be, again, something that's really interesting to see how that plays out internationally. And I guess from an Olympics movement perspective or other sports perspective, I guess is how they will perceive, where they get those money from and how they invest it. I'm sure we'll see that play out internationally as well. I'm conscious that we're talking for some time. I haven't had any hands up. Please, if you are listening and you want to ask questions, please, you should be able to type it in the app, I believe. It had worked in the past that way, or you can raise your hand and I can come to you and you can ask a question directly. I'll be keeping an eye. I am keeping an eye out throughout. So apologies if I'll check my emails as well in a second, just in case people have emailed me directly. Alison, the other thing you were talking about, obviously, which would be remiss of us not to. There's two things, which would be, I guess, the amateurism, and then also all the stuff around the integrity side of college sports. But I guess the two are arguably, depending on which way you come, interrelated. Did you want to talk about that, how that's evolved, and where you see that going over the next year or so?
Well, it's interesting because it's in the news a lot more now when the federal government and the FBI get involved. That gets on everybody's radar screen. So I think we're definitely seeing a lot more of that with the cases from the Southern District of New York with college basketball, as well as with this whole Operation Varsity Blues, which we're all reading a lot about these days.
Can you explain that, sorry, for people,
sure.
Just so, for those people who aren't familiar with it?
Absolutely. So this Varsity Blues has been a hot topic in the news lately, and it's basically there's been evidence found that there are people and there are operations to pay money to individuals to get their kids, sons and daughters, into college, into elite colleges. And they've hidden them, I guess, on athletics rosters. So there's been a number of high profile cases where students are admitted to certain institutions as a rower or as some type of athlete, and they get in, they are admitted in a way that maybe is outside the typical admissions process, or in a way that maybe shortens the process a little bit. They're supported for admission. They get in, and they're not athletes, and they've never had any kind of athletic experience in their life. And there's an organization that is working with people to try to place their sons and daughters in colleges this way. So that's something that exploded in the last month. And so all of us are now back home looking at our processes and making sure that everything is buttoned up. And I think, if somebody's looking for a way to cheat, they're going to find a way to cheat no matter what it is. But I think the key is to make sure that there's as small a window as possible and that we have as many touch points on our admissions process as we possibly can, and understanding that everything, especially at our institution, goes through the regular admissions process, and it isn't up to athletics to decide.
And okay, we've got a question coming in, which we'll come on to. Thanks for that question. I'll bring that up in a second. I think it's very relevant onto this point. But before we do get onto that question, one thing that I was curious about was the investigation, because a lot in soccer, there's a lot of, in football, there's a lot of discussion around regulating agents. And obviously in the NCAA, where you're prohibited from having an agent, it turns out that there's been the FBI are involved in a bunch of investigations where people have, again, tried to work around that system. Maybe you could explain what's been going on there.
Sure, and those investigations have centered mostly around college basketball, and so that's been over the last couple of years where some of those, through wiretapping or through various other means, the Southern District of New York has filed some charges, and it's been found that some are involved in that way, which is inappropriate, I guess. I'm sorry, I've totally lost my train of thought. Give me a.
Oh, that's all right. That's all right. But
give me a cue again.
So they've been working around.
Yeah, I was going to jump in and say, like, the NCAA has been trying to work with different sports properties to try to make sure that they come up with approaches to still protect the athletes, but to the extent where having an agent earlier in the process could help make a decision as to whether or not the athlete should forego NCAA collegiate eligibility to turn professional. If they can
for the people aren't familiar with that terminology, essentially it means stay in university or forgo their time at university to go and be a professional, because there's certain restrictions agreed with leagues, I believe, and the player unions about how long each sport, is that correct? How long time they've got to spend at university before they're eligible for the draft, is that correct?
Right, that's up to each league, yeah.
They lose their ability to compete at the collegiate level. So the athlete has to make a decision whether they wish to continue competing at the collegiate level or cease competing at the collegiate level and then compete professionally. And so as the NCAA has been trying to evolve their approach there to maybe have some agent involvement earlier in the process as these athletes are making these decisions. And I don't know if that was enough filler for you, Allison.
Thank you. Sorry about that. It's age. That actually has been something that has been moving in that direction, with allowing a little bit more access to advisors who can help that process of the decision making, whether it's from the league or from an individual agent, without it being something where the student athlete is receiving benefits. Because one of the principles of amateurism, it's a little bit different than Olympic amateurism in college athletics, is that they can't receive any benefits at all related to their athletics ability outside of what they need for competition or education. So to sign with an agent and receive the benefits and be marketed and all of that would be an issue, and it would affect their ability to be competitive in college or to compete in college. Whereas to get some information, to get some advice, to put a toe in, so to speak, in the draft and declare for the draft but withdraw before being drafted, those are things that are either now allowed or are moving down the pike towards being allowed for those student athletes to be able to assess their market value basically and decide if it makes sense to go back for senior year of participation or junior year, or if they want to go and try the professional waters. And it's also hopefully to protect those students as well from those who are whispering in their ear and saying, you're the best, you should really try this. And then they get out, they don't get drafted, they get stuck, and then they have nothing because they've exhausted their eligibility and they can't go back to college either.
So Jeff, you wanted to say something?
No, I can say, having been over here in London as long as I have, that I've learned that being an international football agent is much better than trying to be an agent in American professional sports. There's almost no regulation of significance. You get paid on both sides of the deal. You get a chunk of the massive transfer fee often, and there's no requirements of any significance for you to have a particular background. So we've evolved toward this model, I think, because of historical Victorian ideals of sport that started in the last part of the 19th century and into the 20th century. And the NCAA has sort of kept that very much alive in terms of its character and its brand and and what it's trying to do in developing American athletes and in the sports.
So what's interesting on that agent's point, and Richard, you know, from the NFL's perspective, again, with this unionization and the strength of the unions in the professional sport, they've been able to, they certify the agents, right? So they control, is that correct, in an NFL, that they control who can be an agent or not? And I know because you've got the NFL agents who come to the SLA conference, right, for their certification each year. Is that a correct assessment of how that operates?
It is. Each agent has to be certified by the union in order to represent players. And most of them do a really good job. Most of them, they understand the rules on salary caps and everything else, and they work with the clubs to get the best deal they can for their client, their player, while still leaving room for success for the club. And it works pretty well.
And so then this is interesting though, because obviously there's been a lot of ongoing litigation around the amateurism and unionization since I've been attending for the SLA over the last 6 years or so. There's been quite a lot of litigation around that, and obviously you have this protecting the welfare of the athlete at stake here. And I do want to come on to the safe sports stuff if you're happy to talk about that, because that's been a big deal in terms of maybe looking at how that will impact on your compliance and so forth at institution level. But Michael Ajapar, I apologise if I've said your name wrong, has asked, how does the NCAA prevent athlete gambling behaviour and attitudes? And I guess like expanding on that, you know, if you were to pick out a more higher risk bunch of individuals in terms of open to manipulation, you know, because they're not paid essentially, but lots of billions of money spent on the sport, loads of people advertising and watching. What's your sort of take on that at the moment? How are you dealing with that as an institution, or more broadly as the NCAA?
It's been interesting and the subject of a lot of conversations over the past year. I mean, for years we've had gambling education, and there's been, you know, don't bet on it from the NCAA and all kinds of materials, and we've shared that with our student athletes. And there have been some issues over the year you hear about with students who are gambling, whether it's on their competitions or on other sports or other schools, but it hasn't been quite as widespread or as obvious. I think you're dealing with maybe some gambling addiction, things like that. But now we're at the point where gambling or sports gambling is becoming legal in many states, and that's opening the doors quite a bit. And I think as an association, as well as on our individual campuses, we're wrestling with how do we make sure that these students are as educated as possible so they understand what the risks are if somebody does approach them and ask them for insider information or asks them to do something that would either affect the outcome of the game or maybe even just the next point. There's so much betting within the games itself that's big money as well. So education, I think, has to be the #1 component. It's also working, the NCAA has different groups that are working on this, made up of people from the membership, but in looking at, you know, how can we regulate this? How can we can't regulate it, obviously, but how can we be involved in such a way that it protects the integrity of the game, #1, and protects the student athlete welfare and experience? And those are the two most important things that we have there. So it's how do you make sure that the students are able to participate without this impacting them? And we're looking at things like, you know, the request for injury and availability reports. That's never something that's been available on the college side, because we all have this protected information from, you know, FERPA, which is the Federal Educational Right to Privacy Act. We're not allowed to release information about our students that's related to their education. Then there's HIPAA, which are the health information laws, and we're not allowed to release information related to their health. So there's a lot of different pieces that go into this, but these are things that would help protect the integrity, would help prevent a little bit of that reaching in to try to get that insider information from the students who are at the source or the coaches. But then also looking at what are some of these other potential pitfalls and educate. I think that's all we can really do, is make sure people understand what the dangers are, both from gambling and from participating in that type of activity, which would, you know, illegally rig the games.
I think from our experience, I think it's going to be an interesting sort of journey in the US, because I think there's, you know, there was someone described, a guy called David Zeffman from CMS Cameron, he said, as everyone else is going to heavier regulation on betting and a more conservative approach, the US is liberalizing. So you're having this crossing of the tides. Thank you for that. Now, on the just touch on, I'm conscious of time here. If there are any more questions, please do ask questions. But just to maybe, and Norm, I know you're heavily involved in the safe sports stuff. Obviously, there's been a lot of high-profile cases in the US, particularly around US USA Gymnastics, which led to the governance issues around the governance, but also around the athlete representation and their welfare. How's that, what's happened in the landscape in terms of, what the impact from that was, and then how things have changed going forward, and how you see that moving forward? I'm not sure who wants to take that, Alison, if you want to break, and maybe Norm. I'm not sure.
Let Norm go first.
So yeah, it's been an evolving landscape since the events that transpired with USA Gymnastics, and so there's been federal legislation that has been passed. There's been a government entity that has opened its doors, the U.S. Center for Safe Sport, that has been focused on providing the rules, if you will, for all sports organizations within the movement, and then they're also trying to make sure that they address it to those other youth sports organizations as well, make sure that they are abiding by those policy procedures. So it has meant a lot more education. It has meant implementation of policies to prevent one-on-one athlete coach or athlete trainer interactions, to start putting safeguards to protect against things like grooming and behaviors that have led to sexual abuse, molestation, harassment, bullying, hazing, all of those things. And so it's still a relatively new area. There's a lot of safe sport cases now that are being brought up through the various grievance channels, arbitration mechanisms that are in through the legislation. So it's been a steadily evolving area. I think it's important. It's been brought to light, and we're still working through how all of this is going to shape.
And I think that's replicated internationally. Everyone's sort of getting to grips with it. We've had issues here, Japan, elsewhere. Maybe Jeff, you can come on and comment to you in a minute in terms of the broader, from the discussion, some of the things you're seeing internationally as both an arbitrator, and also some other issues around doping and stuff like that that we wanted to touch on. But Alison, so it would seem to me that in the college side, and as well, Richard, in the professional side, it seems like compliance and that role of legal and compliance seems to be growing and growing and growing as the remit gets bigger and bigger. Is that a correct assessment, as in terms of the last sort of 5 to 10 years?
I'd say that's probably pretty true. I think from us, it's not the safe sport as much as it is the Title IX and how that applies. I think institutions or colleges in general, not just athletics, have been educating on sexual harassment, sexual assault, all of that for years. And then Title IX, which has also interpretively been expanded to cover sexual violence and sexual misconduct on campuses, we have a lot more responsibility to educate now and make sure that things are handled appropriately and that the information is out there. The NCAA now has a requirement that every year, every student athlete, every coach, and every athletic staff member must receive some kind of training in sexual violence prevention as well. So we're trying to make sure that it's out in the open and that we're able to talk about it and people know what our policies are, and people are also able to feel comfortable coming forward if they have any concerns and not feel attacked, but also understand that there are standards of behavior.
Thank you. Jeff, sorry, over to you then. Yeah.
I mean, I would add to this topic a couple things. One is that this was not a case of the U.S. influencing the international community. This was a case of the international community being ahead of the U.S. in terms of addressing this, specifically the UK and Australia. So long before this was in anybody's wheelhouse in the United States, I took a safeguarding training in the UK as an arbitrator to potentially do this. There must have been more than 16, there must have been at least 16 Premier League clubs represented in the room out of the 24 people in the class. And to me, that was light bulb, like, wow, there's a real problem in football. And they were all dedicated professionals with safeguarding titles. They weren't like just Joe, the vice president, having to do this as part of his other job or her other job. I introduced the safe sport people in the US to the people in the UK when that thing got going as a model to look at. But that one was really ahead of the curve. Now, take that out more globally. You have real issues in my experience in international sport, particularly around cultures, be it within a sport like the martial arts or within a country, where they're very senior junior dominated. So you named one, Japan, Korea, China, very much about seniority being an influencing factor on the way things are organized. And I don't think that we've seen those countries step up. And certainly the IOC has done what the IOC does. They issued a statement that says, oh, this is really bad stuff. We're against it. Something you can't argue with. But
Yeah.
at the end of the day, they're not really doing anything collectively either. And I think that the National Olympic Committees, without a lot of help, are sitting on a potential tinderbox, much like it has gone off in the United States.
I
think
agree with you.
there's also an issue in the United States around sort of how the dispute rules work. And I think we're seeing a pendulum swing that went far to one side because of the harsh facts that have come out about some of these cases. And so very little procedural due process afforded to people that are accused. Some people finding out from the media that they've been charged or that they've had a ban issued before they can dispute it. And I think you're going to see some of that come back. It has to, because it doesn't. I don't think it meets legal sufficiency in terms of just fundamental rights and fundamental due process in the United States, both under the Ted Stevens Act, even with the amendment that was attempted to be made by Safe Sport, and also under other general principles.
So again, can you just explain the Ted Stevens Act? I know a lot of people probably are familiar with this, but just again, for those people who are listening who aren't, and also if you've got any questions, please do submit. We'll be wrapping up shortly, but before we do, obviously it would be great to get some more questions if you have any. Related to any of the things we talked about or anything else you'd like to know about US sport. I think we just lost Alison. But
well, I'll go on and fill until she comes back. The Ted Stevens Act is the statute that governs the Olympic movement. And that statute says that people can't be suspended from competitive opportunities if they're within a protected group of people, athletes, trainers, administrators, officials, without being given a hearing first. And there was an effort to amend that I don't think solved that conflict or solved that issue before applications or before rights are being taken away from accused. Is it a serious issue in terms of what people are accused of? Yes. Should they be removed from intersection with people that they're harming as soon as possible? Absolutely. But in the modern era, there are ways to give hearings quickly and have a third-party fact finder determine whether there's sufficient evidence and sufficient weight to the evidence challenged under cross-examination to determine whether that person's rights should be disposed of, even on a preliminary basis. And that's not been going on. So I think there's room for the system to learn about this, and it would be a shame for one of the cases to go bad in a really bad fact pattern if basic procedural rules haven't been met. But I think they're dealing with it. They're learning as they go.
On this, sorry, Jeff, on this point, we got one of the questions we got asked in the build up to this, sorry, that from Romola Naidu was to what extent does mediation on this dispute resolution side and how it's developed? To what extent does mediation in US sport work? How effective is it? And maybe again, looking at your broader international perspective, what's been successful in the US that you're quite happy with in that regards, and then what are you sort of looking at internationally that you think is better?
So I'm an international mediator. I can say that from my experience, and I say this not lightly and without considering how jingoistic it sounds, but in the United States, we're probably 25 to 40 years ahead of the UK. Well, ahead of the
outrageous. We should end this call right now.
UK, I would say I'd say 15 to 20 years in terms of the market, in terms of the acceptance of mediation as a reasonable alternative dispute resolution mechanism. In the United States, mediation has a role heavily in commercial cases. Some people will say that, and Richard can talk about this maybe, and Allison, on the at least on the collective bargaining side, some people will say that mediation is what solved two of the most recent big labor strikes in sport, the NHL issue and the NFL. The NFL anyway, or the mediation has played a role. Baseball is baseball. The mediation has played a role in that. On that. But if you look at the discipline side, generally internationally in sport, it's almost non-existent. So the number of CAS cases on arbitrations continues to go up, much like you see the esports revenue graph on an annual basis. But the mediation cases aren't coming near that slope, and the number is anemic. And I think a bunch of reasons for that. But part of it is that sport is based in Europe. International sport is based in Europe, and there just aren't, mediation's not as well practiced, well taught, well used, as often as you find in common law jurisdictions.
So I think because we're overrunning, that's Richard's PA telling him to off the call. I was going to ask Richard, but now he's gone. He's back. Is he back again? There we go. Brilliant. Sorry, it's our fault because it's our fault. I'm collectively blaming everyone, but it's my fault for starting slightly late. Richard, and maybe you want to go first, but then maybe Alison. How does it impact you? Okay, go for it. You go for it. But Alison, maybe how does mediation work in practice for you guys? Then building on that.
Yeah, we don't use mediation quite as much as you would see in the legal arena. I think most of what happens on our campus, and it's moderated. It's a little bit different than the legal system, which I think is something that I wanted to point out also with all of these situations, that a lot of times there are legal cases that are going on at the same time as things are being addressed on the NCAA level or on the campus level. So it's a slightly different process. When we look at something in this arena, for example, with the sexual violence, it's going to be based on school policies, institutional policies, as opposed to what the law is. So it's a slightly different process. So we don't use mediation very much.
Could you ever see a unified approach on the NCAA level or not? Is it too much to ask for the members to without state intervention, without government intervention? Is it too much for them to see a unified approach agreed? Or
are you thinking for sexual violence or for
just some of the things that we'll consider? Say, for example, in football, there's generally a standardized process, or you have I think best practice you could argue anyway. There's a strong case to say best practice would be deal with an internal issue, then it goes to a completely independent body to hear or not completely independent body, like perceived independent body to deal with the appeals hearing. Could you see that being as like a standardized approach across the board?
That actually does exist. So right now, if there's a violation or if something is alleged or information comes up, something is brought to the NCAA enforcement staff and they will investigate. If there's something that rises to the level of an issue of a violation, especially a major violation, then there'll be charges filed or a notice of allegations is how it's put. And it goes to the Committee on Infractions. And the Committee on Infractions is made up of members from schools and conferences. And they are actually the hearing body for these issues. When those decisions are made, there is the option for a school to appeal to the Infractions Appeals Committee, which is also a separate NCAA group. I'm actually a member of that group at this point. And so that group hears the appeals of any of the decisions made by the Committee on Infractions. So that process does exist.
To a separate body, though? Would that ever, because we would still see that as being internally dealt with? Would that ever go out? Would that ever go out to a JAMS or a CAS or a AAA or someone like that? Do you see what I mean? And so you guys would have to then, as NCAA, would have to bring the case forward as a prosecutor.
Well, it's funny that you bring that up because in the light of the issues with college basketball recently, one of the changes that was made was this separate process now for certain cases that don't fit within the model for the Committee on Infraction, where they're either egregious or there's other issues that are involved, and there's a lot more details of that, go to the separate alternative resolution process, which is made up of individuals outside of the NCAA. So it's not quite a CAS, it's not an existing group, but it's all people that are from outside who are brought in together to make these hearing bodies. And so that'll be a completely separate track, and there won't be any appeals from that decision. So we do have something along those lines. It hasn't happened yet. It's coming in place now, and then people have been named, and so the process is really firming itself up, but we haven't seen any cases with that yet. That'll be interesting to see how that goes too.
We should cover that. That's another drop down a note.
For another day.
And then Richard, just briefly, we'll come to Richard on the mediation side to answer that, and then Jeff, it might be difficult for you, but maybe Norm, someone asked a question about Castor Semenya. What might happen there? So we'll come to that, and then we'll wrap up just because of people who've got things to do. And you guys, I appreciate it's super busy, and we're starting to run over. So Richard, in terms of the NFL, how did the mediation sort of work? Were you involved in any? Was it effective from your perspective?
The mediation I was involved in primarily was with workers' compensation claims, and you're required by law to go to mediation before you go to court. And we resolved 99% of our cases in mediation. I think it's wonderful. I think it's a great system. With other claims, player grievances, go to a panel of arbitrators that are selected by the union and the league. So they've got their arbitration system set up there. There may be room to insert some mediation for that. Player conduct and player discipline issues, the league is reserving all its rights. The unions, I think, would like to get some more independent voice in there, but I don't know when or if that's going to happen. But I'm a huge fan of mediation in arbitration as well.
It's really interesting to hear how successful it is. Sorry.
That mediation, first of all, a couple of things. There's a wide latitude on the way the mediation can be conducted and the ability for that to go. And mediations typically tend to be the absolute last chance that the parties have to truly hear each other before they're actually litigating, arbitrating, going to battle with each other. And so when you have that forum and you have that opportunity and you have some perceived neutral third party trying to steer them toward an outcome that they can both live with, then, as Richard mentioned, there typically tends to be benefit to that process, and a lot of mediators pride themselves on having super high 90+% settlement rates in terms of their ability to cut through the bluster of each side's stance and get to what the probable outcome would or should be in those situations.
Well, it's not just the last chance to hear each other, but it's the last chance to control the outcome. Once you get past mediation, if you have an arbitrator or a jury or a judge, somebody else is going to tell you what the answer is. It's your last chance as a party to resolve it.
I don't disagree with any of that, except most of my cases come mid-process. So the dispute, there's very little pre-mediation that I am engaged in at any point. It's all after somebody has decided to pull the trigger on filing the litigation, filing the arbitration, and the parties are still trying to avoid getting to this judgment or award that they will control. That's a big issue, and mediation allows you to control that. I'd be remiss to not mention that in the United States, in the Olympic structure, they have something called the Athlete Ombudsman, and that was created in the 1998 amendments to the Stevens Act that I was involved in. And that particular position, I think, maybe Norm has a different view, but he deals with the Athlete Ombudsman on a regular basis. I think that position has gated and kept away from the serious milieu a whole bunch of cases that used to get into the middle of the fray that didn't need to, based on information from a trusted source or from information gathering or the kinds of processes that are not quite mediation, but they're informal efforts to resolve disputes that the Athlete Ombudsman has put forward. This has been talked about internationally as being a possible model, but nobody's actually pulled the trigger on this in terms of international sport. I don't know, Norm, what you think, but you see it. You're a party in that every day, probably.
Yeah, so you might want to describe how that actually works, and so you might want to describe the mechanism of that before actually giving your opinion on it, if you see what I mean, so people can understand what that actual function serves.
Sure. So this would be a situation where an athlete has an issue with a governing body, let's say, and they are ready to bring a grievance or file an arbitration and do that. And they would talk to the ombudsperson who is there to advocate for their interests. And so they step into that mediator role. As Jeff mentioned, I thought his description was good. In that they will go in there and try to advocate and try to understand, okay, well, I've got a very clear picture of what the athlete is saying here. Help me understand the other side. And then they go in there and you start explaining either the policies, the procedures, or whatever. And then they typically try to advocate to try to see, like, what is the right outcome here, and do you really want to go to arbitration and fall on defense of this policy, or is there a workaround that can be reached? Those types of discussions, and they usually tend to be pretty effective on helping make sure that we all really understand the issue that we're going to stand up for in this case. And so I think it helps clarify. As Jeff indicated, I think it eliminates a lot of issues before they get to the point where parties are spending a lot of resources, time, money, etc., to go through the process.
And it's definitely something that's been looked at, and Jack Anderson was quite pro it. Professor Jack Anderson from Melbourne University now, who wrote something for the made a submission, some law in sport actually, to Baroness Tanny Gray Thompson's duty of care review. Before we wrap up then, just because I'm conscious of time, Casa Semenya then, it's like it's a hot topic at the moment. What happens if a case, obviously that went through the CAS procedures, there's an appeal pending to the Swiss Federal Tribunal, I believe, and possible other litigation. How is that perceived through the US legal system in terms of an international federation having regulations, given Title IX, given some of the other issues in the US? How does that pan out? Or how are you watching that at the moment?
Well, I think let's start with Sean. You called this panel the "How does USA influence global sports law?" right? And so it looks like, from a preliminary read here, that the decision that was handed on the Semenya case seems to be looking at the U.S. case as a Supreme Court case, the McDonnell-Douglas case that has the balancing test on this discrimination or allegations of discrimination, and is there reasonable justification for it? Is there a legitimate non-discriminatory reason for this type of conduct? And so it would appear that the CAS decision seemed to look at that Supreme Court balancing test in terms of how they chose to decide that case. Again, not per the letter, I'm not trying to say that, but there definitely seems to be a strong influence of that Supreme Court case in that. So it's interesting. I mean, this is a very complicated issue that could be its own webinar in and of itself. So I don't think we have time to really address that, but if there's other questions you have about that, Sean, I'm happy to talk about it.
Well, I was just thinking, well, what happens if someone was to, with this DSD athlete, was to sort of bring a claim in the US civil courts? How would that pan out? Would it? And then I think you kind of answered it to a certain degree with the referring to that case, the Supreme Court case.
I mean, like, again, this case is about, this isn't about a gender change or anything like that. This is a case of a female that was born female, right? And
yep,
so
absolutely.
The issue is the hormones that she has that rate outside of a range that the great majority of females in those distance events tend to rate in. And so the IAAF is trying to be in front of this issue. Whether they need to be or don't need to be, that's a separate subject for debate, but they're trying to get ahead of this issue on that front, and they decided that in order to have competitive balance, again, their non-discriminatory reason is to have this competitive balance. And does it make sense? Is that the appropriate action? Again, these are things that could be debated, but that's the basis of that decision, and that's the interplay that we have.
I appreciate it. I didn't give you any warning that I was going to ask that question, and I know that it's one that is particularly one, sensitive, and two, complex, and we haven't got the full CAS award yet, so we can't actually really get behind the full reasoning and see all the evidence that was presented, or at least a certain circumstance of that. I don't believe we've got any more. I'm just going to do one last check to see if there's any more questions, but other than that, I'm very conscious of your time. There was a question around amateurism. I'm sorry. I guess we could quick fire around. Do you see this all? It might be Alison. You might want to step away from this question. but
Probably good
for
idea.
the others, for the others, do you see the amateurism approach changing in terms of there's some talk of athletes being able to use their likeness and use essentially their image rights, commercialize on that. Richard, do you see that changing anytime soon?
Well, there's a fella in Charlotte, Jay Billis, who played basketball at Duke, works for ESPN, and is very active in trying to get athletes' rights while they're amateurs. And if you listen to him, then you would say absolutely they're going to get at least the right to use their images and market their images. I really couldn't tell you one way or the other whether that's going to happen. It sounds reasonable on the one hand, and yet I understand the NCAA's concerns on the other. So.
Norm, you might need to back out of this as well. Just thinking about it.
You're like, let's talk about the history of the world. You got 30 seconds.
Exactly.
Okay, Jeff, you'll give me a short, opinionated answer.
Actually, if I do that, then I won't get to be a mediator in any of those cases.
I just think there's so many more pieces to this than most people are aware of that go into it. So it isn't just, does it sound like it's fair to the athletes, but there's a whole lot of other factors that go into that in terms of running a program and what truly is amateurism and what follows those tenets of the NCAA. So I think there's a lot more coming. There's a lot more conversation, and obviously we'll wait for results of appeals, but you know which direction I'm moving in, hopefully.
And to put it people can understand, Sean, I mean, it's like, if we're going to be paying athletes, right, then they become employees, then there's all these labor and employment laws that come into effect, and are you going to be paying the athlete who's number 13, 14, and 15 on the bench, but is practicing just as much as everybody else on the team? Are you going to be paying them the same amount of money as everybody else? I mean, like, that's, I think, what we're kind of alluding to, that there's a lot of different issues associated with this particular question, and so it starts to bleed into a lot of different areas of the law and topics and relationships and the spirit of amateurism and the NCAA, et cetera. And so that's why.
And equity too, right? Because are you going to pay the women's sports as well? And then are schools going to drop the sports that are not money makers in order to be able to pay those that are? So there's a lot goes into that.
And that leads into the sort of IOC Rule 40 sort of discussion as well. So that you can see, just to bring into the international perspective, where there is that, athletes' ability to use their image and likeness during the Olympic Games and etc. So there is that sort of interrelationship. I apologise. I wanted to ask you questions around the breakaway leagues or private leagues, because obviously there was the Alliance Football League that went in place, but we're not going to get into it. I think it alludes to, I guess, how complex the US sports market is, how diverse it is, and the legal considerations. I find it an absolute headache. We've got a US editorial board, and I find it fascinating every time we have the call. It's brilliant. I love coming to SLA for that reason. It's hugely complex with the federal system, and even just watching how the sports betting market and how Passport how that case went was just really interesting. I really appreciate you guys taking the time out of your busy schedule and fitting it in. I hope the people listening, watching have enjoyed this, whether it's on the recorded version or live version. Thank you for those who asked questions. I'm sorry, I don't think I've missed anyone, but apologise if you did submit a question and I didn't get to it. Please send me an email and I'll send you an apologetic response. So for those of you who are interested, though, SLA is open to members both from the US and, as Jeff said earlier, internationally. So I encourage you, we're supporters of the SLA. We work really well together. I love it as a conference. I'm there next week. Look forward to seeing all you guys there. Thank you for your time. Thank you, everyone, for listening. And enjoy the rest of your day. It's evening here, probably mid-morning, lunchtime for you guys, or I should know because we set the time. Lunchtime, afternoon for you guys. And yeah, thanks a lot. Really appreciate it and really enjoyed it.
Thank you. Thank you too. Appreciate it.
Bye. I need to work out how to stop the recording.
Okay.